Good morning, I'm Dhanvi. I'm working as a legal intern at Thomas George and Associates.
I'm Shweta Singh, working as a legal intern at Thomas George and Associates.
On behalf of Thomas George and Associates, we cordially welcome you to the third National Virtual Moot Court Competition. We are pleased to extend a warm welcome to Advocate L. Ravichandar as our judge for today. Advocate L. Ravichandar is a senior counsel for the state of Telangana. He is a rank-holding economic graduate from Osmania University, Hyderabad. He also possesses a law degree from Chennai. He has been practicing law for over 3 decades now. He is also a part-time journalist. Apart from law, he has a passion for debating, movies, classical music, and quizzing.
We will now proceed to explain the time division granted to each counsel in a single team. Each team is allocated 30 minutes to present their case. Each speaker will be given 15 minutes unless indicated otherwise by the team. Placards indicating time will be shown 3 minutes prior to the lapse of time allocated to the speaker, and finally once time has lapsed. 1 minute each will be allocated for rebuttals and sur-rebuttals. Students, please note that disclosing your name or name of your institute shall attract a penalty in the form of deduction of marks.
We have team TGA 12 representing the petitioners and team TGA 14 representing the respondents. Now, with the permission of our learned judge, we shall commence the semi-final rounds of the third National Virtual Moot Court Competition.
Yeah, please go ahead.
Am I audible, sir?
Yes, you are, but not visible.
Am I visible?
Yeah, now you are.
Okay, a very good morning, sir. A very good morning, my learned opponents. This is counsel number 1 appearing on behalf of the petitioner in the case of XYZ versus the State of Republic of Parliament 2. With your lordship's permission, the counsel would like to brief the facts of the case.
Yeah, go ahead.
So digital assets have been on the rise in the Republic of Parliament 2. The government has not enacted any law to legalize the framework of digital assets, digital currency, and NFTs. An attempt to ban this form of digital currency or assets was set aside by the Honorable Supreme Court of the Republic of Parliament 2. While the government continues to contemplate its stance on cryptocurrencies, in the interim, it has implemented a new tax regime aimed at taxing gains and income arising out of NFTs at a 30% rate. The citizens approached the Supreme Court through various writ petitions against the decision of the government and challenged the validity of the taxation imposed on digital assets and the insertion of the new Section 115 BBH of the Income Tax Act. This counsel will be dealing with the first issue at hand, and my co-counsel will be dealing with the second issue.
What is the first issue? What is the second issue?
The first issue pertains to whether or not the government is justified in taxing digital assets, digital currencies, NFTs, etc., which have not yet been legalized. And the second issue pertains to the constitutional validity of the Section 115 BBH of the Income Tax Act.
Tell me.
Your Lordship, before moving to the...
Can this court go into whether the state is justified to impose a tax?
Your Lordships, the Council humbly accepts the position of law that the Parliament has the power to impose taxation with respect to any form of income, irrespective of its legality. However, the council will be contending in a manner that this power should be exercised in a particular manner by using a just and reasonable mind of the parliament.
Maybe they should be doing so. Maybe they should be doing so. But will they do so at our diktat?
Indeed not, Your Lordship. So the Parliament has the final say in this. However,
what role do I have? What role does this Honorable Court have?
This Honorable Court must exercise its power to ensure that justice and equity is maintained.
In a tax statute?
Your Lordship, even though a tax statute...
Just and equitable in a tax statute?
Your Lordship, it is contended that even though a taxing statute should be construed strictly, however, in instances where there are reasonable constructions, then the construction which is favorable to the assessee should be the one which should be undertaken.
Where's the doubt about that? Anyway, proceed.
Your Lordship, before moving to the issue, the council would like to take some time to talk about the maintainability of the petitions. So the petitions are maintained.
One. Has the respondent taken a plea that it is not maintainable?
There's no issue per se which talks
Then
about
why are you creating a dog and killing it?
All right, Your Lordship. The council seeks forgiveness and moves on to the issue at hand. Your Lordship, before moving to the arguments, the council deems it necessary to understand the position of cryptocurrencies in India. So with respect to this, it is to be understood that from 2013 is the time frame when cryptocurrencies were at question in the Indian framework, Your Lordships. So in the year 2013, the RBI issued a circular stating that cryptocurrencies need to have a watch, and they cautioned the users against cryptocurrencies. And this caution was mainly with regard to the AML and CFT norms. And then thereafter, the government as well as the RBI were taking a lot of stance regarding the position of cryptocurrencies. And in 2017, again, the RBI reiterated its position of 2013, which was as per a report of the Indian Institute of Banking. And then after that, in 2018 came the major development when RBI issued a circular which sought to ban and prohibit all sort of activities relating to the trading of cryptocurrencies and the dealing of cryptocurrencies. And in the meanwhile, in 2017, an interministerial government finance committee was formed to review the position of cryptocurrencies, and they proposed.
When was the ban imposed?
The circular came out in 2018, Your Lordships.
So, if the circular is 2018, the interdepartment committee of 2017 is irrelevant, isn't it?
No, Your Lordship, the interministerial.
Unless you are complaining that the right hand doesn't know what the left hand is doing.
Indeed not, Lordship. It is contended that both the organizations do know what they are up to. And pursuant to the 2018 circular, the report was submitted in the end of 2018 to.
The question I'm asking you is, you are referring to recommendations or possible recommendations of a committee constituted in 2017.
Indeed, Your Lordship.
However, you also refer to the 2018 circular banning it.
Indeed, Your Lordship. Yes, Your Lordship.
Now, if that be so, they are aware of it. So, if they are aware of it, how does it help? Because the committees, whatever they are worth, it is not worth the paper on which they're written.
Your Lordship, the council is merely trying to lay the framework or the position of cryptocurrencies in India. And
you're giving me a chronology.
Indeed, Lordship. So after this, in 2019, came the major development where the Supreme Court and the Internet and Mobile Association of India, where this 2018 circular of the RBI was challenged, the Supreme Court struck down the same.
On what ground?
Stating it to be unconstitutional and violative of Article 19(1)(g) of the Constitution.
Because there was no statute.
Indeed, Your Lordship.
Now there is.
Your Lordship, however, it is contended that this particular law should have been introduced by keeping in mind the principles of natural justice as well as
other.
What do
you mean by principles of natural? Can you read out that paragraph of the judgment which said so? In any event, counsel. 1 minute. Let us assume for a minute that the earlier circular of the RBI faulting cryptocurrency in whatever manner it did was set aside by this honorable court on the ground, on whatever grounds it did. Today, there's a statute of taxation. Now, if there is a taxation statute, there is a law enabling the government to deal with it. Where is the question of principles of natural justice there? Your assessment, you will be assessed. Your assessment will follow any other assessment process, which is principles of natural justice, inbuilt, guaranteed.
Your Lordship, the council merely contends that the council humbly accepts the position, whatever Your Lordships is stating. However, it is merely contended on the part of the petitioners to protect their rights in this present matter that the Parliament should have acted in a manner which seems just to the public nature and to the general public will, Your Lordship. To this matter, if Your Lordship permits, the council would like to state a case law.
For what? What principle?
For the principle of natural justice, which the Parliament is presumed to have when it makes any form of laws, Your
We'll
Lordship.
go there later. I don't want case law right now. I'm asking you a simple question. Are you telling me that the Apex Court said even a statute must have principles of natural justice? Before I make a statute, I must inform the sufferer. Is that what you say?
Your Lordship, the council is not referring to the IMA case for this particular instance, Your Lordship. The council merely referred to the IMA case to show the position of cryptocurrencies, and that the Supreme Court struck down the 2018 circular, Your Lordship. This is a separate contention put forth by the council in this matter, Your Lordship.
1 minute, please hold on. Yeah, continue. No, sorry, I didn't get you there. Once again, please.
Your Lordship, the council is not referring to the natural justice principle in line of the IMA judgment. In IMA judgment, the natural justice principles have not been discussed, Your Lordship. The council is putting forth this as a contention with regard to this present matter.
Without case law, without reference to case law, we'll come to case law later. I am asking you a simple question. Suppose Parliament decides to make a law. Okay, let's take the Income Tax Act. Income tax is now going to be levied on, say, pencils. Should notice to all pencil holders be given, or pencil manufacturers?
Indeed not, Your Lordship.
Don't finish. Your theory goes.
And
please understand, how do I give notice to people in a trade which is banned or which is not recognized?
Your Lordship, it is per se not banned or not recognized.
Okay, it's not recognized.
Your Lordship, the further developments show that the government is in a stance where it is not banning it or neither recognizing it legally.
Correct. It's not recognized. Good enough. Where do I give notice? Who do I give notice to? And the moment I give notice, don't I recognize?
Your Lordship, then it is contended that without the recognition or without any formal regulatory framework in presence, the government is not justified in imposing such a high tax rate, Your Lordship.
Oh, there you're right. There you may be right. There you may be right. Can you address me on that? On the need for a regulatory mechanism and proportionality of taxation.
Your Lordship, to this aspect, we can refer to other countries as well, Your Lordship. So at the international level, if we take the example of US, if we take the example of Tokyo, and if we take the example of Canada, these are few countries which have recognized the transactions in cryptocurrencies. However, they have not made them legal tenders per se. So with respect to US and Tokyo, the transactions and the gains arising out of cryptocurrencies are to be taxed under the land and other asset as such, and the property, Your Lordship. And with respect to Canada, the mechanism followed is to consider it as a commodity and tax it accordingly, Your Lordship.
You will also tell me that in a taxation statute, I go to economies which are not paramateria to us.
Your Lordship, does Your Lordship by that mean that the economies which are lower than India per se?
I don't know whether they're lower or upper. USA, Canada, Japan are not the countries which I would think of to compare with India.
Your Lordship, but India is presently the fourth largest economy in the world undertaking, which surpassed UK, and the council feels just that makes a comparison with.
I'm not going into governmental propaganda, please. Where do you get this that India is the fourth largest economy in the world? By what study? Has it been recognized? Have you filed it? Have you stated so? Unless you're a pro-propagandist, why are you giving me these details?
Your Lordship, the council does not wish to propagate or institute any propaganda. That is not the intention of this council.
Proceed with your matter. So your argument, I want you to stick on absence of regulatory mechanism, if any.
So there are no regulatory mechanisms available. And also, with regard to what your lordships raised previously, India is related with the IMF also, your lordship. So it is necessary that these international principles and the policies of these governments are to be considered while.
Now let me again ask you, are the policies laid down by the Japanese courts or government, the American courts or government, and the third example of whichever country you drew, the same?
No, your lordship. The positions taken by those are different, but it is to be considered
Which
in
of
light
them
of.
should I follow?
That's what these petitioners are posing the question towards the government, your lordship. We are the petitioners. We are asking the government this question. Please give us a proper regulatory framework to regulate
Tell
this.
me, there is an income tax regulatory mechanism in place?
Your lordship, with respect to section 115 BBH, it's just the plain imposition of the tax per se. And
Correct,
no...
correct. For every imposed tax, for every tax imposed under the IT Act, there won't be a separate mechanism, isn't it? Regulatory mechanism. The regulatory mechanism is the parent mechanism under the IT Act.
Your lordship, however, it is contended that with respect to cryptocurrencies, which is a very special kind of asset and a very special type of mechanism and etc., a regulatory framework is needed to protect the interests of the citizens.
No, I may be with you on the fact that a regulatory mechanism is required. No doubts there. But why are you excluding the already existing regulatory mechanism under the Income Tax Act? By what law are you excluding it?
Your lordship, we are not excluding any.
Then there is one already in place.
Your lordship, but it needs to be explicitly mentioned that those specific.
So, the law on a subject is what is not implicit, what is not explicitly excluded is implicitly included. Proceed. Proceed, please.
Your lordship, with that aspect, the council also would like to raise another point of argument that the 30% taxing policy is quite vague in this present aspect, and the constitutional provisions regarding the same will be dealt with my co-counsel in the second issue. However, if your lordships permit, I would like to give a small example in this aspect. So if there's a person...
Don't ask for my permission. It is the ball is in your court.
Indeed, your lordship. So if there are two people, a person who earns 2.5 lakh of income and another person who earns 50 lakh of income, and both of these people earn 20,000 rupees out of the gains out of VDAs, your lordship. With respect to the person who is earning 2.5 lakh of income under the present income tax regime, he is not subject to any income tax. However,
because his activity is recognized as legal and valid and whatever. This is not a recognized industry. That is a recognized industry where the man is earning 2.5 lakhs.
No, your lordship, I'm not contesting the position of the imposition of the general income tax law, but with respect to the income arising out of VDAs, the same 30% tax is imposed on both the person who is earning 2.5 lakh as well as the person who is earning 50 lakh of income. Therefore, the person who pays 50 lakh of income under the present regime, he'll pay 30% tax for the 20,000 rupee income which he is deriving out of the VDA. Whereas the person who is earning the same 20,000 as income from VDA and who earns an aggregate of 2.5 lakh of income will be subject to 30% tax for the 20,000 he is earning.
So you want that guy to be taxed more than 30%?
Your lordship, that is not what this council is contesting. The council
who do you represent?
We are representing the petitioners, your lordship.
Who is the petitioner?
The petitioners are the citizens of the state of Republic, your lordship.
Citizens, what's the name of the petitioner? X.
No, there's it's just X.
Is it an association? Is it an individual?
The facts are not clear on the same, your lordship.
In which case, what do you want me to assume? Because your argument presupposes a neutrality on the person being taxed. But now you are drawing a division between two classes of people within the taxed regime. So your neutrality is suspect.
Your Lordship, this
What
was
do I
just
do?
a mere example to
Please
show
don't give me
the
an
very-
example that does not apply to this. Don't give me an example that will cut your feet.
Apologies, Your Lordship. If Your Lordship still wants the council to proceed with the argument in light of the...
Please proceed. Nothing that I say stops you from being dogged.
Your Lordship, if the council would like to go back to its stance on the natural justice by citing just one case law for the reference of this honorable court, Your Lordship.
Yes.
So in the case of Charan Lal Sahu versus Union of India, it was held that for legislation by the parliament, no principle of natural justice is attracted provided such legislation is within the competence of the legislature. And in the present case, the competency of the legislature is not in question, Your Lordship.
So there it goes.
No, therefore, Your Lordship, it is held that as per this case, the parliament has a duty to...
Please read the paragraph.
So it is stated that it was held that for legislation by the parliament...
First read the fact of that case and take me to the relevant paragraph in the judgment.
Your Lordship, if you just give me a minute, I have to take the case law for presentation.
You're arguing before the first court of the land without the judgment in your hands, counsel. And that's the only judgment that's the only judgment you're relying on. You just told me the proposition was that principles of natural justice are not required to be followed in a statute, provided legislative competence is recognized. Correct? Is that what you said?
Your Lordship, it is stated that no principle of natural justice is attracted provided the legislation is within the competency of the legislature.
Wait, no principles of natural justice are attracted if the statute is within the statutory domain of the statute of the parliament or assembly, as the case may be. Correct?
Indeed, Your Lordship.
You agree that the parliament has the statutory power to make a law on taxation?
Indeed, Your Lordship. This council agrees that position of law.
Then where is the principles of natural justice?
Your Lordship, what is enunciated in this case is that only if the competence of legislature is present can the principle of natural justice...
Other way around. It's the other way around. Read your English. If competence is conceded, principles of natural justice don't apply. Were pencil manufacturers given notice before they were taxed? Let me ask you one thing. Suppose the income tax slab for their daily wage earners is increased from whatever to whatever, from 10 lakhs to 8 lakhs. People up to 10 lakhs or 12 lakhs a year are exempt from income tax, right?
Yes.
Suppose the government brings that 12 lakhs down to 8 lakhs and says anybody whose income is above 8 lakhs will be taxed to income tax. All of them should be given notice, is it?
No, Lordship. However, the government will issue a general circular in that regard.
The tax statute is enough. Why will they issue a circular? And if so, we will direct the government to issue a circular in this case if you're satisfied.
Lordship, the main contention of the petitioners is the requirement of a proper regulation without a mere imposition of the tax.
But you're not telling me on the regulation part at all. You're going back to the natural justice part.
Your Lordship, with regard to the regulation part, it is to be considered that the government has imposed other regulatory frameworks. For example, we have SEBI for the Securities and Stock Exchange. We have RBI for the banking system, etc. And the similar circumstance.
Not for taxation.
Because
none of them
Lordship,
have any regulations relating to taxation. They all relate to how the industry must run.
Indeed, Your Lordship. However, considering the high economic aspect of virtual currencies, it is a requirement for a
It is
regulation.
work
Your
in
Lordship.
progress. It is work in progress.
Indeed, Your Lordship, if it's a work in progress, then the imposition of a tax merely portrays the intent of the government to harshly tax the people so as to prevent them from indulging in any form of trading activities. Your
Let's
Lordship.
assume for a minute that is the intent. Let us for a minute assume that is intent. What is wrong?
Your Lordship, that discourages the very economic policies of this country, Your Lordship, with a progressive.
Well, if the government wants to hit its own leg, how am I concerned?
Your Lordship, but it's affecting the petitioners, Your Lordship.
Maybe. Taxation will affect everybody. No? The answer to a taxing statute that it affects me is the most feeble cry.
Your Lordship, it is also contended that an emerging asset, which is not classified accordingly, and this same will be dealt by my co-counsel in a bit detail. However, an asset which is not classified and whose stance is not yet clear, imposing such a taxing policy is not appropriate, Your Lordship.
Did you see your, you have how many more minutes? 3 minutes, is it?
3 minutes, Your Lordship.
Proceed.
Your Lordship, these are the main contentions that this council will be posing for this issue. If Your Lordships have further questions which the council can clarify, it may do so. Otherwise, my co-counsel can proceed with his arguments.
Now, in the judgment that the apex court held that banning is illegal, on what ground did they say so?
The main ground was with respect to Article 19(1)(g) of the Constitution.
Can you read out that paragraph?
Indeed, Your Lordship. So this is the relevant portion.
This is Nariman's judgment.
Indeed, yeah, Justice Nariman, Your Lordship.
Yes. Sitting with Justice Ramasubramanian.
Yes, Your Lordship. It was a
I think it's a judgment of Justice Ramasubramanian, if I'm not mistaken.
Indeed, Lordship. It was authored
Speaking through Justice Ramasubramanian.
Indeed, Your Lordship.
Yeah, tell me.
So the Supreme Court held that in the last 5 years, RBI has not found the adverse impact of the virtual currency exchanges in the market. Further, the stand of the RBI as to virtual currencies not being banned but being regulated is clear from its past circulars, interministerial meetings, as well as the provisions of the Crypto Token and Crypto Asset Banning Bill of 2018. Moreover, there has been no instances where an entity regulated by RBI dealing in the exchange of virtual currencies faced a loss or was adversely affected by its nature of business. Due to the above-mentioned observation, the Supreme Court set aside the circular on grounds of proportionality. Also, Your Lordship, this is
all that the apex court said was an executive order based not on fact will go. How does it apply?
Your Lordship, the council merely stated the IMA judgment in this particular case to initiate the position of cryptocurrency, Your Lordship. The council is not per se relying on this judgment in this particular case. It's not citing this as an authority in the particular case. However, the council stated that to reiterate the position of cryptocurrencies in the year 2019. That was.
And if you notice Justice Ramasubramanian's observations in that matter, the court takes cognizance of the fact that in the past, the attempts by the Reserve Bank of India has been in the nature of regulating the trade. Just read what you just now read again.
The Supreme Court held in the last 5 years that RBI has not found the adverse impact of the virtual currency exchanges in the market. Further, the stand of the RBI as to virtual currencies not being banned but being regulated is clear from its past circulars.
Stop. Therefore, the past circulars of the RBI shows that cryptocurrency is being regulated in the country. So your argument that there is no regulatory mechanism in compared to SEBI, etc., gone. Not regulatory enough is what you want to say.
Indeed, Your Lordship, and a specific regulatory body should be present, just as
Oh.
SEBI and RBI are present, Your Lordship.
Okay. Is SEBI there now?
Yes, Your Lordship, SEBI is there.
All right.
The council rests, Your Lordship.
Thank you.
Thank you.
And my asking you questions has nothing to do with you. It has something to do with your preparation. I just wanted to see how much you face when a hostile judge is against you. That's when the iron gets sharper.
Council is much obliged, Your Lordship.
Thank you. Thank you. Thank you. Yes.
The council number 2 for the petitioner seeks permission to address the forum. This is council number 2 for the petitioner, and this council will be dealing with the constitutional validity of section 115 BBH. The constitution, the council vehemently contends that section 115 BBH is constitutionally invalid on the ground that it's gross violation of Article 14 at various instances of unreasonable classification, and its colorable exercise of its taxing power. So,
what? Colorable exercise of what?
Of its taxing power, Your Lordship.
Okay. That's interesting. We'll hear you on that at length later. Go ahead.
To substantiate the same.
This is back material to 115H of the Indian Income Tax Act, is it?
BBH, Your Lordship. 115 BBH.
Huh?
115 BBH, Your Lordship.
I didn't get the later part. 115?
BBH, Your Lordship. BBH. BBH.
BB.
It's not available in the Act, Your Lordship. It's available on the internet, the income tax department website.
Can the court officer kindly WhatsApp me that provision, please?
If Your Lordship wishes, the council can present the particular provision in the screen.
No, please send it to the court master. They'll WhatsApp it to me.
TGA speaker 12, TGA 12, please put it on the TGA Moot group. We will forward it to sir.
Sure.
And let that not stop us.
Yes, Your Lordship. So for this, I'll be relying on 3 grounds to substantiate the same. The first ground being the disallowance provided, disallowance in case of a set off carry forward of losses and the vagueness surrounding the computation of cost of acquisition.
Wow. I'm not an auditor. This court is not going to audit the income tax. You are dealing with the constitutional validity of a legal provision of law.
Yes, Your Lordship.
There are only, 1 minute, please. There are only 2 grounds on which the legality, the constitutional validity of a provision can be challenged. What are the 2?
One is it's regarding its legislative competence, Your Lordship.
Correct.
And
And
violation
second
of, and if it violates the fundamental rights.
No,
of the
if it
citizen.
violates the basic structure.
Yes, Your Lordship.
Now, can you say that this suffers one of these 2 tests?
Yes, Your Lordship, definitely. If you give your permission, I can go ahead and.
Well, please, every interruption of mine is not an impermission. Don't ask me for permission. It's your right to go on.
Yes, Your Lordship. So at the outset, it is not clear as to in which head gain from and VDA should be put.
You are
In
challenging
either-
it. You are challenging it.
Yes, Your Lordship.
Tell me it doesn't fall under any head.
It is not clear as in.
One counsel,
Yes, Your Lordship.
if it does not fall under a specified head, it falls under the omnibus head.
Yes, Your Lordship, I'm coming to the argument. So what the council contends that it should either be put under the head of capital gains or profit from a business or profession. If you treat it as a capital gain or a profit from business or profession, there's a corresponding set off and a carry forward provision provided in section 72 of the Income Tax Act and section 74 of the Income Tax Act. What this council contends that if it is to be treated as a similar income, why is there a disallowance for a set off and carry forward? While Article 14 provides for an equality clause.
1 minute, yeah. one minute. I'm going to pause it.
Yes, Lordship.
You are taking a certain tax head
Yes, Your Lordship.
where there is allowance of certain deductions.
Yes, Your Lordship.
And saying if this is similar to that, why are there no deductions to this? Correct?
Yes, Your Lordship.
This is your mota argument.
Yes, Your Lordship.
Now let me ask you this. Two different tax provisions on
Yes,
two
sir.
similar products
Yes, Your Lordship.
without the same mechanism of taxation can be valid, isn't it?
Like a pardon, Your Lordship, can you come again?
Let me give you an example. Taxation, income tax taxation on income derived from sale of screwdrivers
Yes,
and income tax derivation of tax from income due to forceps. Two similar instruments of some kind.
Yes, Your Lordship.
One provides for a certain mechanism or a certain taxation, one doesn't. Can it be faulted?
No, Your Lordship.
Then how are you faulting this?
So, Your Lordship, what this council contends that a gain from a virtual digital asset can either be put into a capital gain, ahead under capital gain, or a profit from a business or profession. So
No,
even,
it need not be under both of them. It can be
or either,
simpler.
Your
It
Lordship,
can be simpliciter. It can be income from cryptocurrency, neither as a capital gain nor as a whatever is the other alternative you just gave.
but the income tax department does not provide a clarification regarding its treatment as well.
Therefore, the taxing provision will go.
Not the provision itself, Your Lordship, but it can either be placed in a capital gain or depending on the individual circumstances, Your Lordship.
Okay, go ahead.
So if you place it under, if we place it under a capital gain or a business or profit from business or profession, there is a separate set off and a carry forward provision, Your Lordship. There is a separate set off and a carry forward provision for capital gains and a profit from business. So if we treat it as similar to these incomes, why is there a separate disallowance in case of set off and a carry forward provision? This is in violation of Article 14, Your Lordship. Well, Article 14 provides for equality clause. Similarly situated income cannot be treated unevenly, Your Lordship. Here, similar incomes have a different operation of income tax, Your Lordship. That's the first contention. The second,
One minute, pause. What did you say? Similar incomes?
similar incomes have been treated unevenly, Your Lordship.
Are you showing me a judgment which says similar incomes cannot be tested, taxed separately? Is that your proposition of law?
Yes, that's what the
or are you saying similar can't be treated separately?
What this council contends is that similar incomes should be treated similarly.
One judgment in favor of that.
The council doesn't have judgment for the same also.
Because taxing statutes don't look at equality in terms of taxation. They may look at equality in application, not in imposition. That will be the law. Proceed.
But the government can't have an absolute power in terms of
Yes, unfortunately, in taxation law, it does. Subject to
the
basic structure. Yes, go ahead. Next point.
Next point of contention is again is that there is no classification as regard to the period of holding that the VDA asset holder has. If you have a capital gain, there's a
Council, may I again ask you?
Yes, sir.
You're dealing with the constitutional validity of the provision.
Yes, sir.
Now, you concede to the parliament's power to legislate on cryptocurrency, yes or no?
Yes, sir.
On cryptocurrency.
We concede to it.
Therefore, you are now left with
the basic
the other test, namely whether it violates any known superior law.
Yes, sir.
Or the Keshavananda basic structure. Yes.
Yes, sir.
Hmm.
Yes, there's a tax rate which does not have a classification regard to the holding of an asset, Your Lordship. There's no short-term holding. There's no classification. For example, let's take a capital gain. There's a
Suppose
long-term
your
capital
income
gain.
in the first year of your salary is 30 lakhs or 40 lakhs or 50 lakhs. First year.
Yes, sir. Yes, Your Lordship.
I must have a holding period for you, or can I tax you?
You can tax, Your Lordship.
How is it?
But an income is different from what an income gain from a security such as a VDA is different, Your Lordship.
No.
Gain from a stock.
Please look at the language employed in the statute.
Yes, Your Lordship.
In the impugned provision, where the total income of an SSC includes an income from transfer of any virtual digital asset. The moment I get an income, it falls under the taxing net.
Yes, Your Lordship.
You are saying there must be a cool-off period.
Not a cool off period, Your Lordship. There should be a different tax rate for the period of holding and holding that the asset holder has.
Why should you? Why should it? If it is not applicable for basic income out of income tax, why should it for 115 BBH?
No, Your Lordship, but it is applicable to other capital assets such as if I hold a share for a long period of
You are
time.
assuming that this is a capital asset. This is income simpliciter. They are not dealing with it as a capital asset. No, you are dealing with it as a capital asset.
But there was some classification, Lordship. The motive of a.
Are you suggesting that
Yes,
this
Lordship.
is the taxation which is bad in law for want of classification?
Yes, Lordship. At various instances which will be pointed out and is being pointed at.
Okay. Say so. Say so. It suffers the vice of non-classification.
Yes, Lordship.
Go ahead.
The next point of contention is regard to the cost of acquisition, Your Lordship. With regard to the cost of acquisition, there is again no classification with regard to a crypto user, as in a VDA user and a VDA miner, Your Lordship. VDA miner is one who creates or mints a new asset. For a cost of acquisition, the benefit is only available for the user, Your Lordship. There is a clear-cut mode of computation of cost of acquisition for a miner. This in itself prejudicing a certain class of users.
Go before the ITO and tell him this. Why would you look at the constitutional provision for that? Go and tell the ITO, he will deal with it. He is not disengaged from it. When your assessment is made, draw the attention to the ITO. Let him say he has no power, challenge that in a writ. But why are you challenging the legal provision on that?
What is contained is just there should be a clear-cut classification, Lordship. This is a very vague and a very wide taxing statute, Your Lordship. They're taking into the intricacies and nuances of different asset classes and its uses, Your Lordship. That's the main contention.
Proceed.
I'll be moving to the second sub-issue with regards to the flat rate of taxation, which is a 30% tax. Your Lordship, a 30% tax cannot be issued irrespective of the quality and the quality of the virtual digital assets. While 2+47A of the Income Tax Act provides for a very wide and copious definition for a virtual digital assets, there are different digital asset classes inside the virtual digital assets.
You are only now. Are you advocating for all digital assets, or are you only dealing with cryptocurrency?
All digital assets, Your Lordship.
No. Where do you get that power? How do you become the mouthpiece of, let us say, digital cinema, OTT platform cinema?
Yes,
Who are you to challenge the taxation on OTT cinema?
With aggrieved party, Your Lordship, we represent various petitioners in this case.
So you are also appearing for the producer of Mera Naam Govinda? Yesterday's movie on digital platform, Vicky, what's his name? Vicky?
Vicky Kaushal, Your Lordship.
Vicky Kaushal's movie because you look a little like him?
No, Lordship, but we represent various petitioners who are aggrieved by it. We represent different stakeholders.
You are only aggrieved by cryptocurrency taxation.
No, don't.
Show me show me your bill. Show me from the facts sheet before you that you represent all forms of digital assets. You're raising an interesting point. That is why I'm asking.
Yes, Lordship.
You are able to convince me that you represent across the board digital asset. What you're saying, I will take up.
Yes, Lordship. Just a minute. So the question, while the para 6 reference made to the para 6 that the citizens of the nations were perplexed as to when there is no law legalizing the digital currencies, digital assets, NFTs, etc. The decision to tax gains from the same is unreasonable. Thereafter, various citizens filed is given SLPs, Your Lordship, the clarification is read petition before the Honorable Supreme Court.
I'll give it to you. Go ahead. That's enough for me. Go ahead.
Yes,
well said.
What is contended here is that different asset classes possessing different qualities, Your Lordship. But I'll be giving a simple explanation, Your Lordship, for this. For example, there's cryptocurrencies in VDAs, virtual digital assets. There are NFTs in VDAs, Your Lordship. These possess differently and very diametrically opposite qualities, Your Lordship. For example, a Bitcoin is a fungible token, Your Lordship. For example, if I possess a Bitcoin, Your Lordship, and you as well possess a Bitcoin, we possess the same value at a given period of time. But an NFT is a different asset, Your Lordship. An NFT is a non-fungible token, Your Lordship. Non-fungible meaning these are unique assets. These are, for a better understanding, these are considered as a digital art, Your Lordship.
They are considered as?
They are considered as digital art, but they widely to possess same as a artistic or collectible value, Your Lordship. The value it derives is same as from a.
Correct.
But
at the point of taxation,
yes, Your Lordship.
At the point at the incidence of taxation, they are to be given a value.
Yes, Your Lordship.
And that is the value, which is a value for 30% counting. What's wrong with it?
Your Lordship, we are not taxing gain from a sale of security, from a gain of
You're taxing the asset. You're taxing the asset, period.
But the asset possesses a different.
One minute. The value of 5 acres of land in one place,
yes,
and the value of 8 acres of land in another place are different.
Yes, Lordship.
Correct?
Yes, Lordship.
However, taxation is done on the basis of income deprived out of the sale of those two properties, not on the value of those two properties.
Yes, Lordship.
So also here.
Your Lordship, these possess varied qualities. We are not putting into the same stance the gain from a sale of security and from gain from a sale of a painting or an architecture, Your Lordship.
Why? Why should I not? What inhibits? What inhibits? Understand? Oranges are different from apples, but income drawn from sale of apple and income drawn from sale of orange is the same.
Yes,
at the income level, the quantifying the income level is the same.
But the mode of gaining income and its procedure is quite intricate and complex. And what a cryptocurrency possesses, Your Lordship.
Refined sugar policy, making refined sugar is more expensive than good. Therefore, taxation on income sugar must be less than good. Is it? That's what you say.
The council is unaware of that particular situation, Lordship, but the council still stays with this stance in terms of a different regulation. I'll give you, Lordship, I'll give you a much more complex example as to how this is very different, Your Lordship. For example, the transaction ends in a cryptocurrency where I purchase a Bitcoin and there's an exchange of Bitcoin for it. So there's the end of the transaction. While in an NFT, there are complex mechanisms, Your Lordship. For example, the payment for a non-fungible token can last up to 10 years, 5 years, according to a contract, Your Lordship. These can be done in installments. Further, the creator of a non-fungible token can earn a royalty, Your Lordship. So if I make an NFT and I sell it to someone, and if the second person sells it to a third person, the creator of an NFT can still earn royalty, Your Lordship. So the question is whether the creator
in the year of taxation, he will be taxed for the income. In the year of royalty, he will be taxed for the royalty component of his income tax in the year when he gets the royalty. Simple as that.
But whether the royalty will be taxed at 30% or the existing taxation regime for a separate royalty tax, Your Lordship. That's the
I'm
question.
assuming for the purposes of your argument that it is 30%. How is it wrong? After all, he's being 30% of royalty, not 30% of the total income, right?
Yes, Your Lordship. There's a different, I believe there's a different section providing for a
They'll apply
taxation.
that. They'll apply that. How does it make this law bad?
This is in conflict with the existing provision, Your Lordship. Whether will it come under a transfer of VDA, income from due to transfer of VDA, or a royalty gain at a traditional conventional mode. Your Lordship.
All right.
Next. I'll be moving on to the last sub-issue, which is the colorable exercise of power by the taxation authority. While my co-counsel already dealt that it has a wide latitude power to impose a tax, the same tax is not unfettered, Your Lordship. As my co-counsel pointed out, the motive of the government and the legislature having to prohibit the dealing in cryptocurrencies and other virtual digital assets. When the ban was reversed, when the circular was quashed by Supreme Court in IMA versus RBI, now the government has come with an unreasonably high taxation rate of 30%, Your Lordship. This is discouraging the users in the VDAs and further indirectly achieves the motive of the government and the legislature, which was being prohibited, which wasn't allowed directly, Your Lordship. That will be the last contained, Your Lordship.
I'm listening. Go ahead.
That's all, Your Lordship.
Please repeat what you said.
This is a colorable exercise of its taxing power, Your Lordship.
How?
Yes, Your Lordship. So, a colorable exercise means what is prohibited directly is being done indirectly, Your Lordship. So,
what is directly prohibited? What is directly prohibited here?
The Supreme Court judgment prohibited a complete ban by an RBI circular, Your Lordship.
No,
now,
no, it did not. It only said that circular is illegal. It only said that circular is illegal. It did not say anything more.
Just a minute. But the intention of the legislation of the parliament has been clear, Your Lordship. Be it enacting, trying to prohibit people, then coming with a ban circular, and there was also a draft bill on banning.
One minute, Counsel, would you read this as a taxing provision stopping OTT platforms from making films?
No, Your Lordship, but there needs to be a check and balance. That's the reason.
What it requires will come to later. I'm asking you, does this stop? Is it a law? Is this a indirect method of stopping OTT platform films?
It discourages, Your Lordship.
Any taxation discourages. Even Income Tax Act, salaries are also discouraged because out of your salary, you have to pay 1/3 to the government.
But Your Lordship, the taxation should not go irrelevant with the object of what is being done, Your Lordship.
What is the collecting money? That's the only object of Income Tax Act. It cares little as to whether that industry survives or not, isn't it? That's not the purpose of the Income Tax Act.
But it needs to be reasonable, Your Lordship, and that's
what is unreasonable? 30% is unreasonable.
Absolutely, Your Lordship. 30% is unreasonable.
29 is reasonable. 22, 12, 11 and a half, 10, 9, 8, 7. Which number is reasonable?
Whichever is how is other similar incomes which have been taxed, Your Lordship.
Yeah, similar is OTT platform.
But similar to the VDAs, Your Lordship.
Are you saying this is the only item on the sky that is being taxed to 30%?
No, Your Lordship, but other income possess different qualities, Your Lordship. For example, if you take a lottery is different from what a gain from VDAs. Lottery is a pure chance.
Therefore, what we are concerned is the incidence, not the proportion of taxation. Unless you are able to show me a judgment which says 30% per se is illegal.
Your Lordship, but while the income tax authorities have an unfettered power, we need to have a check, Your Lordship. That's the only argument this council is relying on.
I must play super cop.
Judge, the judiciary must again, Your Lordship, I don't have much contention with this regard. There needs to be some check, Your Lordship. There can't be an unreasonable amount of tax just because it has power to tax. Your Lordship, am I audible?
Yes, I heard you on that.
This will be the last.
All right. Any conclusion?
That as discussed earlier, that it is a violation of Article 14 of the Constitution due to various instances of unreasonable classification and a non-classification, and it is a culpable exercise of its taxing power, Your Lordship.
Okay. All right.
The council seeks permission to move to the prayer for the petitioner.
Yes.
Therefore, in the light of the facts presented, issues raised, arguments advanced, and authorities cited, the petitioners humbly pray that the Honorable Supreme Court of Parliament to find the arguments meritorious and allow the present petitions and strike off the impugned Section 115 BBH of the Income Tax Act as constitutional and pass any other order, decree, or judgment the Honorable Supreme Court deems fit in the interest of justice, equity, and conscience. All of which is humbly pray.
Okay.
Thank you, Lordship.
Yes. Can we go to the respondents?
A very good morning, Your Lordship. This is the respondent. This is the council representing the respondents in the case of XYZ versus the State of Republic of Parliamento. With your permission, Your Lordship, the council proceeds, would seek permission to proceed with the further case.
Yes.
Much obliged, Your Lordship. Your Lordship, would you appreciate a brief perusal of facts at hand?
Not necessarily. Unless you think that I have been misled on facts by the petitioners.
Yes, Your Lordship.
Then only draw my attention to which aspect I have been misled.
Indeed, Your Lordship. Your Lordship, Your Lordship, Republic of Parliamento is one of the largest democracies in the world with...
He didn't say it's a small democracy. There's no misleading there.
Indeed, Your Lordship. The petitioners were stating that this, without bringing up a proper regulation system, the government... One second, there is an issue. Indeed, the petitioners stated that without bringing up a proper regulation system, the government is taxing. The Parliament is making a law to tax on transfer of virtual digital assets.
Will you show me your regulations on digital assets?
Your Lordship, could you please repeat it?
They said that there is no proper regulatory mechanism. Show me the regulatory mechanism.
Indeed, Your Lordship, taxation is the first step to bring up a regulatory system. Your Lordship, the purpose...
So you're saying, even before people were paid salaries, we first taxed them income tax, then we got their salaries regulated.
No, Your Lordship. It is at that point when there was when digital assets were not being legalized, not being regulated. It was at the same time several people started investing.
Do you agree with me that certain digital assets have regulatory mechanisms in place while cryptocurrency does not?
Your Lordship, virtual digital assets that includes cryptocurrencies.
That is why I'm asking you, ma'am. I understand. I
System.
understand that. Too elementary, isn't it, to tell a judge of the Supreme Court that digital asset is not only cryptocurrency but other things also?
No, Your Lordship.
Therefore, I am asking you, there are regulatory mechanisms for certain digital assets, while there is no regulatory mechanism for cryptocurrency. Yes or no?
Yes, Your Lordship.
Then that is what they are saying. They're saying you are putting two things together, one which has a regulatory mechanism, one which does not have a regulatory mechanism. That's what they're saying.
Your Lordships,
How is it misleading?
Your Lordships, the digital asset that they are intending here is only with respect to cryptocurrencies, non-fungible tokens, and anything that is being notified by the government that is defined under Section 247, subsection 47 of the Income Tax Act.
Okay.
Therefore, Your Lordship, it was at that point when these certain stated digital assets were being hugely invested by the public, where there was no legalization or regularization. Before
Even today there isn't.
Your Lordship?
Even today there isn't.
Yes, Your Lordship. Today there is no regulatory system to regulate.
So you admit So you admit to the fact that there is no regulatory mechanism.
Indeed, Your Lordship.
Wait. Your argument is taxation precedes regulatory mechanism. Correct? Let's assume that to be right.
Indeed, Your Lordship.
How does it amount to misleading of fact?
Your Lordship. No.
Be fair to your counsel on the other side.
Indeed, Your Lordship. Indeed.
To say that somebody is misleading the Supreme Court is a very serious allegation, counsel.
My apologies, Your Lordship.
Proceed.
Your Lordships, Your Lordships, the respondents would like to contend on two issues. That is, firstly, taxation is justified by the government, and secondly, the taxation is not violative of Constitution of Republic of Parliament.
So you concede that I can go into the justification part.
Your
You're bringing it into my adjudicatory process.
Your Lordship, we are just it is the duty of the Parliament or the government to answer the questions of the petitioners if they have filed a writ petition regarding it.
Okay, proceed.
Your Lordship, the Council would proceed with the second issue, that is whether this section 115 BBH is violative of Constitution or not. Your Lordship, the section 115 BBH is not violative of the Constitution. The Constitution gives a constitutional right to the Parliament to tax, and this is given.
You mean gives you the power, not the right?
Constitutional power to tax, and this is enshrined under Article 246 and 265. Schedule 7 also gives a subject matter that is related to taxes. No,
please don't waste your time.
Indeed.
They have not said that you don't have constitutional power. Both councils conceded to that. It is the process of exercise of that conceded power that is under challenge.
Your Lordship, yes, Your
Come
Lordship.
there.
Your Lordship, the Parliament.
Please come to your 1115
Yes.
BBH.
Your Lordship, section 115 BBH. Firstly, it states what income would it tax upon. A clear
Any income from transfer.
Indeed, Your Lordship. It can be spending, or it can be swapping, or it can be any transfer. Just a transfer, any transaction would be taxed at the rate of 30%. The Parliament is clear on the stand on the fact that it is taxing on the income from any transfer of a virtual digital asset.
You just now said something more dangerous. You said something very, very dangerous. You said you're taxing any transaction.
A transaction, Your Lordship. Any kind of transfer.
Transaction?
Any kind of transfer, Your Lordship.
Please, any kind of?
Transfer.
So any kind of transfer is taxed.
Indeed, Your Lordship.
Now read the provision. Let us see if that is what the law says.
Yes, Your Lordship.
Yes, read.
Open it.
Where
Where the total income of
green tea.
includes any income from the transfer of any virtual digital asset.
Any income from the transfer or
Yes.
any transfer are two different things.
Your Lordship, the council wanted to state that it is the government, the taxation is on the income, on the income that is coming from any kind of transfer of a virtual digital asset.
But that is not what you say.
The council wanted to imply that, Your Lordship.
Okay.
Your Lordship, when it comes to the question of its violation over Part 3 of the
1
Constitution.
minute, please wait.
Yes, Your Lordship.
Now suppose I buy cryptocurrency, right? I buy cryptocurrency.
Yes.
Who gets taxed? I or the seller?
The seller.
I don't get taxed. I don't get taxed.
Your Lordship, it is
The owner of the asset doesn't get taxed. The seller gets taxed.
Yes.
Okay. Okay.
Yes, Your Lordship.
Then I sell it to somebody else. I get taxed.
Yes, Your Lordship.
Doesn't your legislation suffer double tax, the vice of double taxation?
No, Your Lordship.
How justify it? How do you, the same wealth is getting taxed twice. Strangely, the petitioner does not raise this issue at all. Let me give you an example of the erstwhile sales tax or GST, for example. An asset sold 3 times. Can it be taxed 3 times?
No, Your Lordship. However, this kind of asset that we are talking about is different from that of a stock or a bond, etc., Your Lordship.
Where do you get that from? Because they are not digital, is it?
No, Your Lordship. The stocks have an intrinsic value. This is not there. The cryptocurrencies do not have an intrinsic value. And
then what is the value you give it? The sale value.
The net profit that a person gets after a transfer of that.
When you say profit,
income, Your Lordship. Here the income
means profit, is it?
No, Your Lordship. Income, that is income minus the expenses, Your Lordship.
Where do you get that from, madam?
Your Lordship, in the second subsection, no expenses could be deducted except the cost of acquisition. So we are considering a part of the expense and we are removing the net income and that will be taxed upon.
And this is not excessive. You're justifying this. I'm asking you this. Please take this. Today, cryptocurrency has no mechanism, no platform, nothing. It's an abstract sale.
Yes.
I purchase cryptocurrency for N rupees.
Yes.
Sell it for N plus Z rupees.
Yes.
Now, Z includes various heads of expenditure which you don't know, I don't foresee. But you will tax me for the entire Z quotient without considering the various factors that contribute into the making of Z.
Your Lordship, if you are talking about
if this is not a textbook example of arbitrary exercise of power, show me another.
Your Lordship, Your Lordship, expenditure as such with respect to investing into cryptocurrencies or as cracking a code and getting that cryptocurrency, the only investment, the only expenditure would be the amount that a person would invest from his income that he has from another source.
It could be something else. You don't know it yet.
Your Lordship, the respondents, the council would like to just state,
Because you admit to the fact that it is abstract as of today, etc., etc.
Yes, Your Lordship, it is abstract as of today. It is abstract as of today. The government does not know from where these bitcoins have arrived, these cryptocurrencies have arisen, where is its jurisdiction is from.
That's a poor reflection on your policing skill sets.
Your Lordship, this is a new market that has just arisen over.
The first thing is you'll snatch.
No, Your Lordship, that is not the intention of the legislator. The intention of the legislator is to understand how much income is being generated and how it is generated. As of now, when we talk about equity or any other sources of income, that is channelized via.
For what? Equity in tax law?
No, Your Lordship, I'm talking about stocks and the taxation under various heads such as capital gains or business income, various assets. Apart from
what point you're driving home?
I'm just trying to make the point that the government is unaware of how much income is flowing in and out of the country.
Therefore, I'll tax them 30%.
That is one reason, Your Lordship. And secondly, it is a highly volatile asset that does not have a predictable nature. One day it would be 10,000, and next day it would be 70,000, and the next day it would drop out.
And therefore, at what stage do you tax it at? 70, 10, where?
Your Lordship, only when we are taxing it, the income minus the cost of acquisition when the person has lost that asset.
1 minute. Therefore, the first seller sells it for 10,000. Correct?
Yes, Your Lordship.
According to you, it's volatile.
Indeed, Your Lordship, it is volatile. It is volatile.
But you charge it, you tax it at 10,000.
No, Your Lordship.
Because that's the income that he derived, no?
Your Lordship, I would like to just explain how this taxation happens.
Please tell us, because your taxing statute is silent, you will at least explain.
No, Your Lordship, the statute is the section is very clear in its nature. For example, a person buys a cryptocurrency at 100 rupees per se, and after some time he sells it at 10,000. At 10,000. Now, what would be if he gets the 10,000? Now, what would be deduct from it? And the deduction
you
would
want to skip the 100 sales?
10,000 minus.
You want I'm asking you the first sale, imposition of the first income. He buys it for 100?
Yes, that is the cost of acquisition.
No, it's a cost of acquisition for him.
Yes, Your Lord.
For the guy who sold it at 400 rupees?
No, Your Lordship, the person who is selling, when the person who is selling, that person would be What
is the origin? Which is the origin of this tax then? What is the origin of the cryptocurrency?
That is not the origin is itself not known, right?
Therefore, the original man who gets it for 100 rupees is not taxed.
No, Your Lordship, the point that
because you don't know when it came from.
Yes, Your Lord. For example, Your Lordship, the council would like to explain it in just simple terms. If a person is buying a cryptocurrency at 100, and after
from where?
From another seller, from another investment, or from another investment.
That is where Madam, you're trying to oversimplify an answer that you're not able to give me. You are going from 100 to 10,000 or 1,000. I'm asking you, what about the 100 man?
That 100 man who has bought it from someone else, his income would also be taxed.
From where? Where does he buy? According to you, you don't know where he got it from.
The buyer would not be taxed, Your Lordship. The person who is selling would be taxed. Okay,
Okay, 1 minute. Okay. The buyer will not be taxed.
Yes.
The seller will be taxed.
Yes.
The guy who has sold it for 100 rupees is a seller or a buyer?
The buyer who has sold it for 100 rupees, at that, when he's selling, that would be the seller. And when he's buying it at 100.
The seller at rupees 100 is getting an income
Yes.
from the amount he bought it from?
Yes.
You don't know from where he bought it. How do you tax him?
Your Lordship, we would only tax it at when he would transfer it to someone else. We would not transfer it when he
What kind of a taxing mechanism is this? Crude, to say the least. Anyway, proceed. Proceed.
Your Lordship, when it comes to the questioning of its violation over Part 3 of the Constitution, the petition was also stated it's violative of Article 14. The Council would like to state that
Their argument is that there is no regulatory mechanism. Can you answer that?
yes, Your Lordship, there is no regulatory mechanism of it as of now. The petitioners also stated that it is a special asset which needs a special mechanism. Considering it to be just during the past 2-3 years, where this has been a tremendous rise into investments into these, and the government, not only this nation, many nations, most of the nations are unaware of its origin. And at this point, it becomes the duty of the government to understand how income is flowing in and out of this mechanism. Taxation, if we tax it, the people would come up to the government, show how much income they are generating, how much they are losing, and accordingly, we would be able to understand the nature and bring up a proper regulatory mechanism. Secondly, if the petitioner's contention is that it is not coming under capital gains, you're treating it as capital gains or business income, Your Lordship, the nature of this income is different.
How is it different?
Yes.
It is coming from out of a sale, isn't it?
Your Lordship.
1 minute, madam, please. Please tell me how it is not a capital gain.
Your Lordship, it is, Your Lordship, if we talk about capital gains, it is
capital gain, if I understand, is I invest on something, I sell it. The difference in my investment cost versus the sale cost is capital gain.
Yes, Your Lordship.
Out of that capital gain of X rupees, X percentage is taxed.
Yes.
Capital gains today is taxed at 12% to whatever percentage. Now you are charging for this capital gain 30%.
Your Lordship, this is not a capital gain.
Explain.
Yes, Your Lordship. It is a sale of not just an asset, a virtual digital asset, which does not have firstly an intrinsic value, which does not have its origin. When we talk about capital gains, for example, stocks or bonds, they are company ownership assets. And there is a share ownership.
Wait. Capital asset of land sold?
Your Lordship?
Capital asset of land sold.
That would be taxed under capital gains.
Now, a land that was belonging to me through my great-grandfather, which came to my great-grandfather 400 years ago. It had no value then. So no value minus what is today's capital gain, is it?
No, Your Lordship.
Then that's what you're now saying.
Your Lordship.
Exactly what you're now saying.
Your Lordship, that is not what the council wants to state. The nature of a virtual digital asset is not completely into the nature of a capital gain, nor it can be just into an income from other source that is of the nature of gambling or a horse race. This is somewhere within between investing, and that does not have a basic prediction over its volatility. And secondly, Your Lordship, its value does not increase with the inflation. It is not related to the inflation of the nation or the country.
Where do you get that, madam? Where do you get all these theories? Why are you bringing 1 minute? Why are you bringing inflation on what? On income tax, do you use inflation?
Your Lordship,
Your
Lordship, indexation benefit is given based on the inflation, Your Lordship. And when we
get please, ma'am, don't throw these theories at me like that. Where do you get inflation quotient in income tax?
Why
are you getting that in?
Your Lordship, inflation is one of the factors that would determine the value of an asset. For example, the value of a land.
Where do you get that, madam? Please, where do you get that? Inflation is only for cost. For example, today, the value of a land, 1 minute, the
Yes, sir.
value of land constantly is increasing in the sub-registrar's office, right?
Yes.
Inflation means prices coming down, the rate has to come down, no?
It should match
Does
with
it happen?
No.
Why are you giving me such a bad example?
Your Lordship, here in the given section, indexation benefit is not given. And the council would like to explain why indexation benefit is not given to
Not interested.
cryptocurrencies.
Not interested. I am only asking you
Yes.
your justification for what they said was high incidence of taxation of 30%. That's what you're addressing, right?
Yes, Your
That
Lordship.
is the question you're addressing. Address that.
Your Lordship, it is not a high rate of taxation.
You are the Mughal.
Your
You can fix it at 30%.
No, Your Lordship, it is not confiscatory in nature.
You don't want to be as honest as Aurangzeb and say, I will do the GR tax.
Your Lordship, even though the parliament has a right to tax it, it should be reasonable in nature, and that is what the parliament is doing right now. The government is doing right now. The state right now, if we talk about income from other sources such as gambling or horse rides, they are taxed at the rate of 30%.
They are banned activities.
Your Lordship, certain kinds of gambling are allowed, and it is over those where 30% is taxed upon. Here, taxing itself means that the state is not banning cryptocurrencies or any other virtual digital asset. This should be considered as a welcome move. That the people can trade in that. They have the right to trade that is given under Article 19, and this is given. And they have the parliament has clearly stated a law that defines what is a virtual digital asset. Secondly, it has given a clear computational provision on what it is charging tax, that is income from transfer of any VDS. It is not giving any set off of any loss which can be carried forward as well. And second, the cost of acquisition is only something that can be deducted, and no other expenses could be exempted while calculating the tax. This is a clear law that has been started, that has been made with through the budget, which followed the basic procedure of law. Your Lordship, if we talk about,
please come to 2B.
Yes, Your Lordship.
How do you justify that?
2B. No set off of loss from transfer of any virtual digital asset computed under
Justify that to me.
shall be allowed against income computed.
Justify that.
Yes, Your Lordship. Okay, this is regarding, can you just shift it? Yes, Your Lordship, this is regarding the set off of loss and carrying forward of it. Several assets, the income tax department has a right to either set off the loss or even carry forward it. When we talk about capital gains, certain set of loss is given. When we are talking about speculative business, there is no set off that is given, whether it cannot be carried forward as well.
No, madam. If I am able to quantify loss, it falls out of speculation, isn't it?
Your Lordship, I'm just giving examples where set off of loss is not given under the income tax.
Why would you give me an example if I can understand the theory? If I can't understand the theory, if I'm a moron of a very high value according to your assessment, then you will go and give me an example.
Your Lordship, that is not the intention of the council.
Please come to the theory and tell me first.
Your Lordship, the income tax.
How can you say I will not deduct loss?
Your Lordship, that is given under Section 70 of the Income Tax Act.
What?
Save as provided, otherwise provided, income from, can you just share? Income from one source cannot be set off on another income, on other source.
Absolutely right.
under
They are not saying set off my loss in buying of shares and bonds with cryptocurrency.
No, Your Lordship.
The argument,
Your Lordship. Yeah. Yes, please, Your Lordship.
no set off from loss of this asset. So why are you going to section 70? That's another. For
No, Your
example,
Section 70 is with respect to same head of income, Your Lordship. Same head of income.
no, please read 70 again. Show me the income tax. Read section 70 again.
Set off of loss from one source against income from another source
From another source, madam.
under the same head of income.
Correct.
The head of the income is, the head is under section 2 subclause 47. That is virtual digital asset. I'm not, the council is not making a statement.
Ma'am,
The set off is being given.
and what that could be. There is otherwise provided where the net result of any assessment, in respect of any source falling under any head of income other than capital gains, is a loss. The assessee shall be entitled to have the income of such loss set off against the income from any other source under the same head.
Yes, Your Lordship.
Then how do you get over section 70?
The council here wanted to make a point that set off over the same head of income is not allowed by the law. The council would like to just take 4 minutes to speak about it.
Capital gain, right? You concede that this is not a capital gain.
Indeed, Your Lordship.
Therefore, read what 70 says. If it is not a capital gain, 70 simpliciter applies. Now read it.
Save as otherwise provided in this act, where the net result for any assessment year in respect of any source falling under any head of income.
Where are you reading from?
From the IT Act.
Which provision of are you 70? 71.
71. One.
Yes, read again.
Save as otherwise provided in this act,
Correct.
where the net result for
Yes.
any assessment year in respect of any source falling under any head of income other than capital gains is allowed.
Now wait.
Yes.
Any income falling from any head of income.
Under any head of income. Yes.
Correct. Then read. The
Other,
assessee shall be entitled to have the amount of such loss set off against his income from any other source under the same head.
Your Lordship, this is I would like to bring your notice to the first few words in the section. Save as otherwise provided in this act.
Therefore, you are saying that this provision that comes in for the first time under the Income Tax Act will bulldoze that provision, and you will say it is not a capital gain, but yet this you tried to justify it under section 70, correct?
Yes, Your Lordship.
Where is the justification?
Your Lordship,
70 only says if there's some other provision, you can do it. That's all.
if we create another provision that does not get set off, that can be allowed.
All right, I got you. Okay. Anything else?
Your Lordship, the council would like to just state that
1 minute. Court officer, isn't her time over?
I would like to just conclude in 3-4 minutes, Your Lordship.
No,
Just-
you won't get 3-4 minutes unless your other friend's time is going. I've heard you completely and I've heard you out completely. We'll go to the next.
Good afternoon, Your Lordship. This is the co-counsel.
Yes.
Your Lordship, just to bring to your notice, I would like to state that it is completely justified that bringing up the taxation of cryptocurrencies. Your Lordship, by bringing up, I'll just state an example of the current scenario in 2021. The biggest Indian crypto...
Examples instead of principles. What is this new way of discussing law?
Your Lordship,
I'm reading a textbook for examples. Are you teaching me?
no, Your Lordship, apologies. but
Example, tell me the proposition of
this is
law.
not this is not an example, Your Lordship. This is a fact, the news fact that we would like to state.
Yes.
The biggest Indian crypto broking platform, CoinSwitch Kuber, registered a 3,500% rise in transaction volumes and touched 14 million users in the year 2021 alone.
You're not taxing them, isn't it? 1 minute. You're not taxing them, isn't it?
We are taxing them, Your Lordship.
No. How can you impose a tax on income gained which was not taxable? That 3,200 crores or whatever number you're throwing at me,
yes,
and the date of such income being derived was not taxable.
No, Your Lordship, it was not taxable. Your Lordship, the council is just stating this to bring to the notice of this court.
That amount of 3,000 odd crores is perhaps earned because you don't have a regulatory mechanism in place.
Your Lordship, this is to show that there has been an increase in the recent times, and therefore there was a need to immediately do something about it. And therefore,
there was a need to see that people don't earn income, is it?
No, Your Lordship, it was not about the income earning, but it was about how much income. Your Lordship, just to point out, cryptocurrencies and various such assets, in a matter of seconds, millions of dollars, millions of rupees can be transferred from one part of the globe to the other, which means that the government is basically left out of the picture, wherein millions of Indian rupees are going out of India. And to get a hold of that information, the only way the government
Madam, are you taxing import or are you taxing the asset?
The asset itself.
Then how much of money is going out of the country? Do you get that from?
No, Your Lordship, how much of money is being flowed in such assets? Your Lordship, once the money goes into the investment of an asset, the asset is what is left, right? And the asset itself has no origin and it can't be traceable, which makes it important for us to know how much money is going into such intangible assets. So therefore, the first step is to tax and find out and get a picture of what is going on in the economy, how these cryptos are working in the economy.
This is a tuition fee. They are paying tuition fee for your tuition, is it?
No, Your Lordship. They are paying for what trade they're carrying out. They're making an investment. So for that, they have to pay certain tax.
That's not what you're saying. You are saying you want to know this. I want to know how much is happening. Therefore, I'm taxing it.
Your Lordship, it is humbly pleaded, Your Lordship, that there is no other way. In the case of cryptocurrencies or virtual digital assets per se, there's no other way other than taxation that the government could have employed at that point of time.
This is an appalling argument. This is an appalling argument to say that I have no other way of knowing how something is going on in this country. Therefore, I will tax him.
Your Lordship, at a larger medium, the council again tries to reiterate and tries to satisfy the judge on their questioning. Is that
have you thought of taxing sex workers?
No, Your Lordship.
Why?
Your Lordship, we're taxing the income per se. It's not about.
No, have you ever thought of taxing income on sex workers?
No, Your Lordship.
Why? You have not regulated it. You don't know how much of money is coming and going. It's one of the largest trades across the globe after weaponry and drugs. Or are you taxing drugs or income?
No, Your Lordship. Your Lordship, another, to answer this question, Your Lordship, we do not need to, if the council likes to point out that, the petitioner has said that with the point is that they're not giving out the legality. The government is not giving us a legal status of this, and it is taxing us irrespective of whether it is legal or illegal.
That's not what they argued. That is not what they argued. That's not what they argued. On the other hand, what they argued was, they tried to ban.
Yeah.
They were unsuccessful. And therefore, they are doing it indirectly by taxing me of 30% of what I get. And therefore, they are achieving indirectly what they could not do directly. And that amounts to colorable exercise of power. That is the argument.
Yeah, Lordship, the council would like to differ on this point of the petitioners. wherein it is banning is a complete stoppage on all sort of transactions and all sort of this thing, and it is prohibited by law. However, here we're not prohibiting by law. We are simply stating that we will, whatever income you're getting, come to us, we will tax it. We will just take a part of that income. Your Lordship, it is normal that it is in the power of the government to take income from any revenues earned by the citizens. It is for the welfare of the citizen that the government taxes. That is clear on the part of Constitution to give the power to the government to tax. On that same basis, if any asset is generating income on the citizens, then the government definitely has the right to tax.
An asset which you cannot quantify, an asset which you cannot see, an asset which you say, I don't know anything about, an asset about which you say, I have no regulatory mechanism, I know nothing about it. I will just enter at one point where I think is a convenient zone of entry, and from there I will tax.
Your Lordship, this is the most reasonable aspect of our taxation, section 115 BBH, Your Lordship. We have taxed it at a 30% rate, which is not too high, not too low.
I'm not going into the rate of tax.
Yes,
they are also not. They did not argue rate of tax. Why are you arguing rate of tax?
But Your Lordship, if there is an income that is coming out of
what are the broad points you want to make?
Your Lordship, the broad point is that we have a right to tax. Firstly,
who said no?
Yes, Your Lordship.
Then why are you arguing a point which nobody is arguing?
Because we have a right to tax. We are taxing on 30%, which is a reasonable tax considering the.
Did they say 30% is unreasonable?
Yes, Your Lordship. They have funded.
No, that is not what they said. They said if there are different kinds of digital assets.
Yes, Your Lordship.
You can't put all digital assets into one basket and tax them together.
Your Lordship, we're coming to that. Your Lordship.
No, therefore, your second argument is gone. What is your next argument?
Your Lordship, coming to the point where different digital assets are being taxed at the same rate.
That is one argument. What else do you want to talk about?
That and the cost of acquisition, Your Lordship. The question why we have not deducted the cost of acquisition.
Proceed.
Your Lordship, firstly, why we're not taxing? If we look at it, digital assets, if we look at it, yes, we agree that the origin, the way they're acquired, everything is different. Your Lordship, but that is the intent. We are grouping similar things together. Your Lordship, all are virtual digital assets in the end. The principle of ejusdem generis can also be taken into this consideration.
How can it? Because not all digital assets have unknown source. Not all digital assets are physically not present. An OTT film can be converted into a physical. They are present, isn't it?
Yes, Your Lordship. Yes, Your Lordship.
How do you put both of them together?
Your Lordship, by putting, by what we're doing is we're broadly categorizing them.
No, you're not interstate categorizing them is the complaint.
Yes, Your Lordship. We are broadly putting all of them together, and then we have introduced, that is the reason why we have given the deduction of cost of acquisition, wherein the acquisition cost of any of those different assets is cut off. It is not taxed, right? It is minus, with which the income earned is the only thing that is left, and the profit that we're earning from those assets is being taxed, which in our contention, Your Lordship, is justified.
I'm listening, go ahead.
And Your Lordship, also, just to point out to this court, that virtual digital assets do not follow the rules of demand and supply like other forces do as of now, Your Lordship.
Why?
Your Lordship, because the rise and fall in these assets is without any reason. Most of the time, it is without any per se increase in demand or decrease in demand or supply, and there is no such supply origin as well.
I'm not asking you why there is supply and demand. I'm asking you, why are you applying the theory of demand and supply?
Yes, Your Lordship, because to come to the point that since there is no demand or supply, we have to come to a decision where we are reasonably trying to put a tax rate.
And that is 30%.
Yes, that is 30%.
Then how do you justify non-set of loss?
Non-set of loss, again, Your Lordship, the loss again is something, it is a speculative, it's a very volatile asset, Your Lordship. And the loss and profits are—
Where does the volatility come from?
Your Lordship, because of not following
the market.
The market.
So market means demand and supply.
Demand and supply.
Which you said there is no demand, there's no supply.
Your Lordship, it does
Your
not—
argument. I wantonly took you there.
Yes, Your Lordship. I will clarify that, Your Lordship.
Mm.
I'll be happy, the council will be happy to clarify that. So the council is referring to the forces of demand and supply, which is not being the rules or the rules laid by economists at large of demand and supply. The already, whatever market, we have a tangible market.
1 minute. I'm not saying the microeconomic theory of demand and supply curves cut at a certain point and then that is the pricing. I'm not talking about that.
Yes.
Neither are you, I agree.
Yes.
I am only saying, why did you introduce
Yes.
the demand and supply theory to the market? Because you said that is how market forces function. It's
Yes.
your theory, it's not my baby. I'm not killing your baby. You create a baby and kill it.
Yes, Your Lordship.
Why are you bringing that theory in?
Yeah.
Is it your argument? Yeah.
Yes, Your Lordship. Your Lordship, the petitioners have drawn an comparison with how VDAs are taxed and how other assets are being taxed. And they have asked us, they have put this question.
One minute, please hold on. Please hold on for a minute.
Yes, Your Lordship. Indeed.
Oh, this is gone again. Can you? I wanted to mark it. Yeah. Right now? Yeah. Yes.
Yes, Your Lordship.
Yes.
Your Lordship, we have brought this volatility and demand and supply here because the petitioners have questioned upon why there is not a similar comparison of various assets as to this VDAs. They have set up a comparison wherein, other assets are being taxed a certain way, but VDAs are not following such taxation. We are justifying in order to justify that these VDAs are different. We brought in the applicability of demand and supply forces, Your Lordship. Finally, it is just to state that these VDAs per se are completely different. There are new set of assets that the government has to deal with right now. They do not follow the natural forces, the forces already determined. And cryptos and VDAs have almost a separate nature of
Ma'am, I must confess to you, I don't know where you started from, where you're heading to, and what you're trying to drive at. I am clueless. What is it that you want to say?
Your Lordship, the the respondent would only contend that it is justified. The taxation is justified on grounds which my co-counsel has also given. There is no question about constitutional validity. There is
Why?
Your Lordship, because my co-counsel has just given the arguments for—
She just dictated from the Holy Bible.
No, Your Lordship.
The justiciability of a constitutional validity is for us to determine, right?
Yes, Your Lordship. These are the arguments laid out.
Madam, please, two. The argument of theirs is that this is a colorable exercise of power by Parliament.
Yes, Your Lordship.
Please address that argument.
Sure, Your Lordship.
Because your colleague hasn't answered that for me.
Okay, Your Lordship, this is not a colorable exercise, Your Lordship, because
declaration.
We're trying to get into the argument, Your Lordship. So we are not banning the trade. However, we are actually—
That's no argument. No, they are not saying the ban is colorable exercise. They're saying imposition of tax is colorable exercise.
Yes.
We all know that you've not banned it. That's why you've taxed it.
Yes, Your Lordship. Your Lordship, the council is just getting into it. Your Lordship is allowing trade by taxing it, is actually working towards allowing this trade as directed by the Supreme Court itself to
Why
us.
Income Tax Act is estoppel against ban, is it?
No, Your Lordship.
Then
That's not-
you, for example, you tax tobacco,
Yes, Your Lordship.
you can ban tobacco.
Yes, Your Lordship. We can
Then
ban it.
how is it? How is it?
That's not the intent, Your Lordship. The
So
intention.
please don't come up with an argument that this is to ensure non-ban. It's nothing. There is no estoppel. There's no declaration in your statute that you will not ban it.
Agreed, Your Lordship. Agreed.
That's no argument.
They agreed that taxation nowhere guarantees not banning. But however, it is not indirectly. What we're trying to say is it's not, as the petitioners contended, it is not indirectly trying to justify the ban or to indirectly trying to lay out a ban.
That is one aspect. The other aspect was putting all of them in a basket is also colorable exercise.
No, Your Lordship. That has already been answered by the council, Your Lordship. We'll reiterate. Your Lordship, that is what we're doing by giving them the opportunity to deduct cost of acquisition. With that, we're actually treating the income as same, and all are similar in nature as it comes to the volatility of all these assets, Your Lordship.
How is OTT platform film and cryptocurrency volatile in the same manner?
They are not, Your Lordship. We are not.
Then both of them are assets on the digital platform, which are digital assets, whether capital asset or not, and you are taxing them at the same 30%, isn't it?
Your Lordship, the council would like to clarify that we're only talking, that the council is only referring to the virtual digital assets under cryptocurrencies, NFTs.
No. Please read your section 1115 BBH again. Where do you draw? That is their complaint, madam, that you have not classified them in the manner your argument is classifying them.
Your Lordship, the classification is not necessary in this case, is the justification.
You just now said they're all non-volatile. They're all equally volatile.
Yes.
When I showed you the example of two, you said they are not together. I showed you that they are indeed together. Again, you go back to the volatility argument.
Your Lordship. Yes, Your Lordship, because we are just trying to say that that we are taxing tobacco income as well. We're taxing the income that we're getting, the tobacco income, as Your Lordship has stated, in a different manner, but and VDAs require a different manner of this thing. It is not that coming to the banning and indirect colorable legislation point, Your Lordship.
Madam, one of the arguments placed before by the petitioners was that your government, I'm assuming Parliament and government function in tandem with one another.
Yes, Your
had constituted some kind of a committee.
Yes, Your Lordship.
On cryptocurrency.
Yes, Your Lordship.
Have they come up with any report? Was that considered by your parliament, by the parliament before they made this change, your finance department?
Certainly, Your Lordship, it was considered.
What was the recommendation?
Your Lordship, the recommendation was to the RBI recommendation. The petitioners, the respondents are aware of the RBI recommendation to ban. However, which was
Please, madam, answer my question.
Yes,
the RBI ban ran parallelly with the constitution of the committee.
Yes, Your Lord.
The division bench of our court said that that can't be done because this intent is not so.
Yes, Your Lord.
It acted at cross purposes. That is all they say. I'm now asking you something else. I'm asking you what happened to the committee's recommendations?
Your Lordship, the government does not have an answer as to the committee report.
All right.
Does not have a justification.
And it is your argument that I can't go beyond the statute, what went in and what came out of that while making the law.
Your Lordship, the council does not understand.
Okay. Anything else?
That's it, Your Lordship. We end our argument. Your Lordship, we would now like to move on to the prayer.
What prayer can you have in their petition? Can
Your
you
Lordship,
pray anything?
Your Lordship, we do have a prayer.
How can you?
Your Lordship, ultimately we are representing the side of the government, so the government does have the right to.
Can they, as respondents, have a prayer?
Your
Except
Lordship,
and dismiss the writ petition.
Your Lordship, our the prayer itself is for the Supreme. It's a request to the Supreme Court to quash the writ petitions based on the arguments presented.
Hold on. Thank you.
It was an honor pleading before this court, Your Lordship.
I'm not sure. Anyway. Court officer, court masters,
Yes, sir.
is there any rebuttal from the petitioner side? Tell them that they don't have to give rebuttals only because they have an opportunity. I will minus marks if they give rebuttal on issues not raised.
Petitioners, you have 1 minute for rebuttals if you want to start.
I hope the speakers heard what I said. Rebuttal will be for 1 minute and only on issues raised by the respondent. And if I see you argue on anything other than what they argued, I have the right to minus marks.
Petitioners,
Petitioners are the public rebuttal, the Lordship.
Did you
And
hear what I
briefly-
said?
Yes, Your Lordship.
Go ahead.
Firstly, with regard to the argument of the learned opposing counsel with regard to the question of intrinsic value, Your Lordship. It has been stated by the opposing counsel that the intrinsic value of the virtual digital asset is unascertainable. So, in this aspect, the question is how if the intrinsic value itself is not recognized, how is the gain recognized, and how the fair market value of such VDAs are recognized? For example,
Why should they talk about fair market value? They are only reducing it to income derived from sale.
yes, Your Lordship.
So why should they look at all that?
Lordship, VDAs need not be transferred only for money, Your Lordship. VDAs can be exchanged for other VDAs as well. I can exchange an NFT for another NFT, Your Lordship. So how is the gain on such income is ascertained? So for that, then a fair market value is to be ascertained, Your Lordship. With regard to that, there is no regulation as to how regulation or rules regard to how the fair market value is ascertained, Your Lordship. The next will be that even if you consider this as a volatile and a speculative trading or using of VDAs, there's a separate provision again for speculative loss, set off of speculative loss, Your Lordship, in section 73 of the Income Tax Act. Another point of consideration is the question of object of the taxation, Your Lordship. As the opposing counsel have argued that due to increase in volumes of trade, due to increase in gains, is the government sole object of taxation is regulation? Is that question, Your Lordship? Is the object of taxing section 115 BVH is only for regulation? That's it, Your Lordship.
Yes. Okay. Thank you.